morning. Welcome to Open House 2021. I'm Professor Chen. The areas of law that I teach and research in include public and constitutional law, health law, and immigration and refugee law. What I'd like to share with you this morning is a piece of my research, which I've spent a lot of time grappling with. And it concerns international migrants' entitlement to healthcare in high-income countries such as Canada. As Canadians, we often pride ourselves for having a universal healthcare system. Right? Instinctively, the notion of a universal healthcare system connotes a publicly funded healthcare program that is made available to all those people residing in a particular place. Now, after all, if you look at the Cambridge English Dictionary, you'll see that it defines universal as existing everywhere or involving everyone. But I trust it is not news to you that the Canadian healthcare system in reality falls well short of such universality. Many international migrants living in this country are not entitled to healthcare, and they must pay for their hospital and physician services out of pocket. For example, in Ontario, most newcomers moving to the province from abroad must wait for 3 months before they're eligible to apply for the provincial health insurance plan. Some migrants, including international students and those without legal status in Canada, are excluded entirely from Ontario's healthcare program, even if they may have lived here for years. As I see it, there are two ways to reconcile this reality with the image of Canada as a country that supposedly has a universal healthcare system. Neither, frankly, speaks all that positively about the status quo in Canada. The first way of reconciling is to accept that our current healthcare system is under-inclusive, meaning that although the original architects of our healthcare system did intend for it to cover everyone residing in Canada, this vision has failed to come to fruition. An alternative explanation for the status quo is that when we say universal healthcare, we never truly mean universal in a literal sense. To put it differently, it was never intended that the universe of our universal healthcare would include every resident of Canada. What this underscores, right, is an exclusionary posture towards migrants and the status of migrants as the proverbial other that is undeserving of government-funded healthcare. My own view is that regardless of which of these stances that we embrace, it is unconstitutional. If we choose to understand the status quo as under-inclusive, right, in light of the healthcare system's original universal commitment, this would arguably run counter to the spirit of equality rights as enshrined in Section 15 of our Canadian Charter of Rights and Freedoms. And not everyone that should have been entitled to healthcare has been made eligible. On the other hand, if we choose to explain the status quo by accepting that certain migrants, if not all of them, are never part of the intended universe of our universal healthcare to begin with, this exclusion seemingly contravenes Section 7 of the Charter, which guarantees the rights of every person in Canada to life and security of the person. Indeed, a series of charter challenges against the government's denial of migrants' healthcare coverage has been advanced along these lines. So far, unfortunately, they have not had much success, at least not in our domestic court. But in 2018, the United Nations Human Rights Committee, in a case called Toussaint and Canada, found Canadian government to have violated the International Covenant on Civil and Political Rights by denying publicly funded healthcare to an undocumented migrant who had lived and worked in the country for over a decade at the material time. The committee ruled that Canada has breached the right to life of undocumented migrants here in Canada by limiting their access to essential healthcare, even in situations where there's a foreseeable risk to life. It also found Canada to have contravened the guarantee of non discrimination under international law by making an unreasonable distinction in this context between those who have legal status in Canada and those who had not been fully admitted into the country. The Canadian government, however, has chosen to ignore the UN Human Rights Committee's views, arguing that the committee, despite being subject matter experts, had erred in its interpretation of international human rights. A group of lawyers, which I'm privileged to be a part of, is now taking further legal actions against Canada in hope of ensuring that the UN Human Rights Committee's decision will be given proper consideration domestically. And so the advocacy work continues. Okay, I hope this gives you a peek at the kind of work that my colleagues and I do here at U Ottawa. Now, I'll be available at the virtual fairs later this morning if anyone is interested in speaking further. I look forward to meeting you then. Thank you.